The modern single-family court operates as a closed circuit. It is no longer an open forum where parties simply arrive and expect a judge. Over the last decade, the judicial system has re-engineered its rules to deflect litigation. The courts now require parties to attempt alternative dispute resolution before granting audience to a judge. For a family law practitioner, managing this gateway is the primary responsibility. Every legal strategy depends on first establishing the administrative right to occupy the courtroom. Without mastering these entry protocols, a practitioner cannot initiate proceedings. Even the most compelling case is irrelevant if the court refuses to issue the application. This procedural threshold is defined by Section 10 of the Children and Families Act 2014. It acts as a hard barrier, requiring applicants to attend a Mediation Information and Assessment Meeting, or MIAM, before advancing a case under Practice Direction 3A. A relevant family application encompasses the vast majority of family disputes, including private law proceedings regarding children and all standard applications for financial remedies. The burden is asymmetrical. Attendance at the MIAM is compulsory for the applicant. While the respondent is encouraged to attend, the initial legal hurdle rests entirely on the party attempting to initiate the case. Attempting to bypass the statutory threshold without administrative clearance leads to an immediate application rejection and invites judicial sanctions against the legal representatives. When an application arrives, it is processed by a gatekeeping team. Their role is to review the initial paperwork, allocate the case to the appropriate judicial level, and issue standard directions. This team cannot allocate the case or issue directions without verified proof of mediation compliance. The system is designed to stall any application that lacks the proper procedural certification. Form SM-1 provides the documentation required to satisfy the gatekeeping team. This document serves as the formal signal that the applicant met their pre-filing obligations. Validation is restricted. Neither you nor your client can sign this form. It requires the signature of an authorized family mediator to confirm that a MIAM took place or was deemed unsuitable. To ensure the validity of the referral, the mediator must include their Family Mediation Council registration number. The court verifies these credentials before proceeding. Form FM-1 is the administrative trigger for judicial allocation. Without it, the application remains stagnant at the administrative desk. Practice Direction 3A provides an exemption matrix for cases where mediation is inappropriate. Bypassing the MIAM requirement is only permitted if the situation fits exactly into one of these specific pathways. The domestic abuse exemption requires objective evidence. The applicant must demonstrate active police involvement or the existence of a protective injunction, such as a non-molestation order. Urgency exemptions are limited to situations involving immediate risks to life, safety, or child protection concerns, where social services are already engaged. Logistical exemptions cover circumstances where a mediator is unavailable within 15 miles, or where a party is residing abroad or in prison. The financial pathway is highly restrictive. It only applies if the dispute is limited to financial matters and one of the parties is formally bankrupt. Practitioners bear the burden of documenting these exemptions accurately on the application form. While evidence isn't submitted at the point of filing, the claim must be ready for judicial scrutiny. These are not loopholes for negotiation. They are rigid, evidence-based overrides that must be proven at the point of entry. If no exemption applies, the client must engage with a family mediator. This role is strictly defined as an impartial negotiator focused on future arrangements, not a therapist or counselor. While many mediators are legally trained, they are prohibited from providing specific legal advice to either party. They manage the process, but you manage the legal strategy. Lawyer participation in the sessions is heavily restricted. If present, you cannot advocate, speak for your client, or interfere with the negotiation. It is an expensive way to observe a meeting. Your primary influence occurs outside the mediation room. You add value through pre-session strategy, drafting the referral letter that frames the issues, and analyzing asset valuations for your client. For eligible clients, the public funding framework supports this route. Legal aid options, such as Family Help Lower, are specifically structured to cover the advice required during the mediation process. If the parties reach an agreement, the mediator drafts a non-binding record of the terms, known as the proposals. The parties then return to their lawyers. You translate those proposals into a formal consent order and submit it to the court for final judicial approval. This shift moves the practitioner's value away from traditional advocacy towards strategic preparation and precise legal drafting. Expect any claimed exemption to be scrutinized. At the first hearing, judges actively interrogate whether the bypass of the MIAM was procedurally sound. The 2020 case Re B established a clear precedent for how courts handle uncooperative litigation. It warns against bringing high-conflict disputes to a strained family court. In Re B, the judge issued an explicit warning to practitioners.
The court is not the default venue for differences that can be settled elsewhere. If the court determines an exemption was applied incorrectly, it has the immediate power to adjourn the case. The judge can halt proceedings entirely and order the parties back to mediation, effectively resetting the case timeline to day one. For practitioners, the consequences are financial. Judges are authorized to impose cost sanctions on legal representatives who waste court resources with unnecessary applications. The mediation mandate is actively enforced. Attempting to enter the system without valid documented cause is a direct path to professional censure. This timeline compares court litigation against the speed of mediation. Systemic delays mean a 4 to 6 month wait just to reach the first hearing. Mediation offers more flexibility. It can often be scheduled and fully resolved within a fraction of the time required for court. To manage the backlog, many courts list hearings at risk, meaning a case can be vacated at the last minute if the court's daily burden is too high. These procedural rules exist because the justice system cannot sustain the sheer volume of private family disputes. It requires the gateway to function correctly to maintain order. The architecture of the single-family court is designed to filter out rather than invite in. A practitioner's primary duty is managing client expectations. You must move them away from a default litigation mindset and toward alternative resolution. You either earnestly support a non-court settlement or you provide the precise evidence required for a practice direction exemption. These rules represent the gatekeeping mechanics of the modern justice system. Understanding them is a prerequisite for any family law practice. Mastery of Practice Direction 3A is the only reliable way to secure a judicial hearing.